Good morning. This is Rich Sierra, president of the Florida Small Business Legal Center. This is episode number 56 of Business SOS. Thank you for listening to me and listening to the show. And I hope you're getting information that is valuable to your business as you navigate the challenging waters of legal issues that you might face in your business journey. As I open the show, if you want to reach me, you want to send me a legal question, anything that you might have a question on, please send it to rich@richsierra.com. If I select your question, and we'll talk about it in the show, and I'm not going to mention your name, I'll send you a free copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them, which is available on Amazon, Barnes & Noble. You can ask for it at your local bookstores. Also, if you're interested in learning more about our legal services, you can go to our website at floridasmallbusinesslegalcenter.com. So today, I've been talking about, I have the theme of the 5 common mistakes, 5 things that can go wrong. So today I'm going to talk about 5 things that can go wrong in your deposition. And a few episodes back, I talked about what is a deposition, how to prepare, and I spent an entire segment on preparing for a deposition. But I want to talk today more focused about 5 things or 5 mistakes that are common mistakes that some clients have made and some people make when a deposition, when they're faced with a deposition, whether it's a deposition as a party or a deposition as a witness. So I want to talk briefly, what is a deposition? A deposition is basically you're going to provide testimony under oath. It could be via Zoom, it could be in person or telephone, but it's under oath, and it is not necessarily inside of the court, like in a trial, but it's considered just as important as if you're actually it's a court proceeding, but it's not it's not in the trial. And you're going to have a transcriber. The court reporter is going to transcribe your testimony. You might have that also be taken in the video. The opposing party or the attorney who once called for the deposition or summons you to have the deposition taken will be asking the questions, and you're supposed to answer those questions on the road to your best of your knowledge. So just briefly, just want to give you that background, that context, so I can talk about 5 things that go wrong in your deposition. Depositions are important. They're important, especially for those who are asking the questions, because the objective is to obtain testimonial evidence that will be used at trial or could be used at trial, whether it's against you as a opposing party or you're basically gathering information as a witness to be used for that particular, whether it's plaintiff or defense, for that attorney's client's case. They might ask for documents, they might ask for deposition testimony, but you need to answer those truthfully on the road to your best of your knowledge. So one of the mistakes that I see parties making, and some of my clients have made, and also some of the deponents that I take the position of for cases, is lack of preparation. And the lack of preparation in cases is something that is avoidable, because all you got to do is review the documents that very likely will be brought up at the deposition. So if you say, for example, you're the plaintiff, you're the one suing, you're suing a partner, you're suing a vendor, you're suing somebody who breached a contract. So you want to review the complaint, the lawsuit, because the lawsuit is really what you're alleging against the other side. You want to review all the correspondence. There's usually email communication, and breach of contract cases, a lot of documents. So for the most part. So there's email communication that has being exchanged between yourself and the defendant. They have maybe text messages that have been exchanged. There's information that you have received from the defendant also in response, because before a lawsuit, there's usually a lot of communication that precedes the lawsuit. It's very seldom that you go from no communication to a lawsuit. It just doesn't happen. There's usually something that triggers the lawsuit. There's some communication about the misunderstanding or the issue that triggered that dispute. So that communication is essential. Review how the relationship began, and anything that most likely will be asked of you in the deposition, and your attorney should have a deposition prep before the actual deposition to really discuss with you the topics that very likely will be brought up at that deposition, so you can be better prepared. So the lack of preparation is one of the keys. And if your attorney said you're going to have your depo, it's going to be this day, ask for that prep. Say, you know what, I want to have a meeting to talk to you about how should I prepare for this deposition, what do I need to bring, what I need to review, and to be able to prepare and have a much better depo. So that's mistake number one. I might go back to that. And one of the things that could happen if you're not prepared is that you will have inaccurate or inconsistent testimony, which later on could be an issue for you, especially if you're the plaintiff in the case. Another thing that I'd like to share with you when we talk about preparation is that it's important to tell your attorney anything that you believe will come out in this depo. The other side is prepared. The other side has probably done a background check on you based on the public records. The other side is ready, prepared, is going to ask you questions, and most likely going to ask you questions that your attorney does not anticipate. So if there's anything in your testimony that you believe is going to come out of the depo, it is important to share with your attorney beforehand, so your attorney is prepared for that question, number one. Number two, address how to handle that particular question that may not be favorable to you in that case. And cases are not, when I get calls often from potential clients telling me this case is a slam dunk, we have everything. It's very seldom you have a case that is 100% slam dunk. It doesn't work that way, especially in business litigation, because it's about relationships that began in good terms, which later on, for a number of reasons, the relationship went sour, and then it triggered an apparent breach of a contract or some other claim, and then the relationship went south, and then that's what happens. So you have a lot of testimony about who said, she said, and a lot of conflicting testimony. So it is very seldom that you will have every single thing in your case, in your testimony, that is going to go in your favor. Some things may not be in your favor. The question is whether it is a minor item that you can be overcome, or is it a fatal issue that has to be addressed that could affect your case. So those are the things that your attorney will know how to handle, or should know how to handle, but you have to bring it up to the attorney. The last thing you want is that your attorney hear for the first time testimony that is not favorable to you, you basically answering the question that you're required to answer, and then your attorney hearing it for the first time after you had a number of conversations with your attorney is going to ask you, why you didn't tell me that? So we don't like surprises in litigation, especially when it comes from our clients. Just as I mentioned before, share the good, the bad, and the ugly. It can only help you. Number two, a second mistake that I see, which really ties into lack of preparation, is the inconsistent testimony. It is important that that your story is consistent, that in the preparation of the complaint begins from the time that you speak with your attorney, that first initial meeting, that initial consultation, which you are telling your story to the attorney, and the attorney, based on that information, is preparing, and I'm talking to you as the plaintiff, it is preparing that lawsuit based on your narrative. So that is important. And sometimes the attorneys, they're humans, and they can actually write something wrong. They can misinterpret something that you said about the facts. And we take the information as you give the information to us, then we take that information and convert it into a lawsuit, into the complaint. So it is important that before that lawsuit is filed, that complaint, it is accurate as to the facts, what I call the general factual allegations. You provide that to us. We cannot make that up because you were part of that, the history of that event or what happened, that relationship, that partnership, that vendor. We were not there. So you know that story better than we do. We know the law. We know what causes of action to file, whether it's a breach of contract, tortious interference, trademark infringement, Deceptive Practices Act. We know what to file, and we know the elements based on the facts. That you're not supposed to know that. We know that. But we prepare that lawsuit based on the narrative that you provide to us. So the reason I'm mentioning that is because the attorney, the defense attorney, is going to look at that complaint and it's going to ask you questions about the allegations of that complaint. And it is important that you review that complaint before it goes out in a filing and goes into the court system. Because those words, those allegations, you're going to be challenged on those. Because that's what defense attorneys do, and I do both. I do plaintiff and defense. I'll look at those complaints very thoroughly. And if somebody's suing my client, that plaintiff be ready to be asked questions about those allegations. In my job, and what I try to do is finding consistencies in their testimony versus what is written in the complaint. So it is important that you read your complaint and you're consistent with your testimony to what the lawsuit states. Another item of inconsistency that I see ties into lack of preparation is the interrogatories and the production requests that you provide. So that's why it's important that when you look at the lawsuit, you're going to be asked questions under oath under interrogatories. And I went in a few episodes back, I talk about discovery and I talk about requests for production, requests for admissions, and requests for interrogatories, and the importance of completing those accurately as you can, of course. But you will be challenged as the plaintiff. They're going to look at the complaint. They're going to look at your answers to the interrogatories, and then they're going to compare that with the documents that they already have through request for production with respect to the emails that you have exchanged with the other side. All that has to be consistent, because a good defense counsel is going to look, this is the complaint, this is the lawsuit, here are the interrogatories, but I find this email which contradicts something in the complaint. So I want to talk about that. So that goes to lack of preparation, but a mistake that I see here is that there's inconsistent testimony on the part of the plaintiff, or the plaintiff does not remember certain facts that are essential to the case. And it's going to be difficult to move forward if you're not able, as the plaintiff, to substantiate with proper evidence, proper testimony, what you're accusing somebody else that they did in order to collect some money from them. So consistency is very important. Whether you're a plaintiff, whether you're a defense, it's essential. But that's the second mistake that I see here happening. Mistake number 3, some things that can go wrong in a deposition. This happens very often, and it happens in a depo. Sometimes you can have depositions that go 3 or 4 hours. Sometimes that can go for an entire full day, and it can spill over to a second day. You will get tired. You're in the morning, you're fresh, you're ready to go. After 2 hours in, you're going to begin to get tired. 3 hours, forget it. Then you're going to get hungry. Now, this is not an interrogation that you're going to be going 8 hours without a break. Usually in instructions the attorney tells you, if you want to take a break, let me know. But they usually ask you to do it after you answer a question, so that way that you don't have a question and answer hanging. You basically complete that and you take your break. There's also lunch breaks. And your attorney should coordinate with counsel about the logistics, about how long the attorney expects to have the deposition go. And there's usually a range, depending on the material that the attorney and the topics the attorney wants to cover. So if it's anticipated that it's going to be a full day, then they should agree and say, you know what, let's go up to we start at 9 o'clock, let's go through noon, we'll take a few breaks, let's take a half an hour lunch break or 45 minutes, and then let's reconvene back again. So that way you will be able to take breaks throughout the deposition, but inevitably you will get tired. Attorneys also get tired through a depo because it's a very intense process. You're listening actively. You're asking questions. You're there in the hot seat, as we call it. And it is not a fun process, but we have to do it, okay? So and what happens here is that sometimes witnesses tend to volunteer information. And it's because people get tired. At the beginning, you're very on guard. And I'm not saying don't provide answer the question truthfully, but you have to listen to the question that is asked of you and then answer the question. But don't volunteer information. And I'll just give you an example of that. Sometimes they ask you a question that, say Mary sent you, do you remember that Mary sent you an email telling you that she wasn't happy with your services? And I'm just using that as an example. I hear say, you know what, I don't remember those emails, but hold on, let me check my phone. I have them all here. For the most part, I laugh when that happens because a good attorney is going to say, okay, so where are those emails? You have them on your phone. Okay. How many of those emails do you have? Okay. How long have you had those emails? Okay. From what time to what time? Do you have them anywhere else? And what follows is like you tell the opposing side attorney said, I need to preserve, all those emails because we're going to request copies of those emails that he just mentioned. So I'm just giving you an example. Or looking at dates. The attorney's responsibility is to refresh your recollection. And sometimes the witnesses, in an effort to help and assist, then they're volunteering information that they don't need to volunteer. So listen to the question carefully. Don't volunteer information, but answer the question, of course. But it happens very often. Some things because people want to help, or another thing they do, they bring a bunch of documents with them for a deposition. Your attorney has to tell you what to bring, what not to bring, and what happens is that and again, this happens every often. It said, I don't remember that, but hold on a second, I have it here in my notes. And anything that you have there in your notes, the attorney can ask, I need a copy of those notes. So just please understand that volunteering information at a deposition can be a problem. And an example says, I told so-and-so, I was talking about it with this person. Oh, I sent that email. I sent the text. And so just listen carefully. And you see me throughout this podcast, I'm talking about listening carefully because I want to make sure if you have one takeaway here is preparation. There's two takeaways, and to listen. Those are two key important components of proper deposition preparation. Another mistake number 4, see here, is displaying negative emotions. And what happens is that when you are being sued, it's just not fun. And even when you're the plaintiff, it's still not fun because it's an adversarial process. And the defense is doing his or her job to protect his client. And the plaintiff is doing his job in trying to, advance the case to get a final judgment, whatever the case may be. So it is an adversarial process. But what I advise my clients when they have a deposition, be professional, be cordial, be courteous. Yes, they're going to ask you questions that you might not like, but always stay professional and stay courteous. It does not help the case if you become argumentative with opposing counsel, especially have it on video. They try to play that video. If you need to take a break, take it, but it's good to take a deep breath and get through the deposition as professional as you can, answering the questions, but without displaying negative emotions, start name calling opposing counsel, and because the moment that you lose your cool, then it becomes a different dynamic for that deposition. And it might actually be easier to elicit that testimony from you because you're not thinking clearly. So you have to kind of maintain your cool, take deep breaths, take the breaks that you need to take, and be able and have and get through the deposition as well as you can. Your attorney will be there to represent your interest. And if there's a situation that things become argumentative, things become to the point that the deposition is not productive, sometimes the attorney might have to intervene and say, you know what, we need to take a half an hour break and reconvene back so we can continue. And if it becomes something that sometimes attorneys lose their cool to, and the attorney becomes, too aggressive or too with the client, then the attorney has to step in and say, I need you to take it a step back, ask your question, but you're not to raise your voice to my client or become argumentative, or we're going to stop this. Okay? So we'll keep it professional, we'll keep it factual, and the less emotions you share in terms of negative emotions or aggressive emotions, so to speak, the better you are. Just answer your questions, get through it. Eventually, the deposition will pass. You answer your questions, and it's over. So, but that could actually affect the deposition and affect how you respond to them, because you're not going to be at your best. It goes without question. Resting properly is important. Preparation is important. But, getting a good night's sleep before a deposition, having a good breakfast is very important as well. And also having a deposition, especially if via Zoom or video, you want to have it at a place that is quiet, a place that you can actually don't have interruptions. Don't do it from your car. Don't do it from your iPhone, because you might have documents to have to be shown to you, and it's going to be difficult to be able to go through a depo when you're reviewing documents through an iPhone. And so what I usually do with my clients, we do our prep in the same environment that the deposition will be conducted. So the deposition is in person, we probably do a prep in person. If the deposition is in via Zoom, then we'll do a Zoom preparation. But also ask the client, especially if it's via Zoom, to go into the same place in the same computer where they're going to be responding to a depo. So I don't want to basically have the prep via iPhone and then find out that the Wi-Fi in the house is not good. So I want to basically have that environment where the deposition will be conducted from and have the prep there. Why do I do this? I do it to make sure that the Wi-Fi is working well. If it's a weak Wi-Fi, if it's something that, it's going to be spotty and I'm going to have a lot of freezes, then I'll come up with an alternative. Maybe go to my office, or maybe go to a deposition place that we can actually have the proper Wi-Fi and not have those interruptions. Why is this important? It's important because if you're already nervous, being in a deposition it's just not fun. It's something that we have to get through. And you already have anxiety. The questions are going to be asked, what are going to ask me, and, am I going to get the right answers? So if you're going to have a greater level of stress, if you cannot connect to the internet, if all of a sudden your Zoom is not working, and it's just avoidable stress, and to get through a depo. And I had about last year, I was going to conduct a depo, and I'm laughing because it's kind of funny now, and the client was actually doing it from her car. And I said, well, where are you? And so I'm in my car. And I said, okay, this is not going to work, because I have the documents. It's going to be a few hours of deposition. And plaintiff's counsel did not know that was going to happen. So clearly they didn't talk about this beforehand. So what we did is say, you know what, let's go ahead and reschedule for another time. It was not something that was urgent or required to be that particular day. So I spoke with opposing counsel of record and said, listen, let's go ahead and reschedule for another time where she can be at a more convenient location where she can actually have a proper deposition, a more comfortable setting, and we can actually get the proper examination and not be encumbered by these challenges. So that's what we did, and everything worked out, and we took the depo another day. But, it's important to talk about that with your attorneys to have the proper preparation in the deposition. last but not least, mistake number 5 is misunderstanding the questions. And I talk about this. It goes back to listening and not trying to anticipate what the attorney is going to do, what questions he's going to ask or she's going to ask. So often, sometimes clients hear a question, they misinterpret the question and provide volunteer information they're not supposed to volunteer, or provide questions that answers to a different question that was not asked in the first place. Another mistake that I want to mention here is that often the clients start a sentence, "My attorney told me," or "I told my attorney." And when you start that, you'll see attorneys jumping in and say, "Stop." Because whatever communication you have with your attorney, it is confidential attorney-client communication. And also, any information that your attorney told you is also confidential attorney-client communication. So it is important to note that information is, you're not supposed to share that information in a deposition. And to the extent that that's the only way you need to answer the question, then you got to preface by saying, "My answer contains information that I share with my attorney, and I really cannot disclose it. I need to discuss it with my attorney first." Okay? But I want you to protect that information, not volunteering. The misunderstanding the question is very important. It's another common mistake. And it happens usually towards the end of the deposition when you're already tired, or when the attorney is trying to go back to some questions earlier just to see if he can get a different answer. So there's a lot of different techniques that attorneys use to try to get the information from the deponent. And we're professionals. This is what we do for a living. Fortunately, if you have one depo in your lifetime, that's plenty. But if you do have too many, then I don't know, you have too many losses. There's been conversation to be had. But the point is that you have to listen. You have to be on top of your game and active listening throughout the entire deposition, especially at the end. And that's what's important. Take breaks, have your snacks, and take your breathers, because it is the question that is asked at the beginning of the deposition. It's just as important as the question that is asked at the end of the deposition. So misunderstanding the question is a mistake. And my advice to the clients, because I do not know when they misunderstand a question or not, usually until after the question is answered, is basically, if you misunderstand the question, you say, "I'm sorry, I do not understand the question. Can you clarify it for me, or just repeat it or rephrase it?" So that way you can get clarification on the question that is being asked. So that's something that you can ask for clarification on the question. You can ask to read it again. Sometimes the attorney's Wi-Fi might not be as clear, might be spotty, and then the question might not come through well through your audio. So you can ask the court reporter to repeat it. And also think about your answer. It's not something that you're supposed to answer immediately. You can take a pause for a second or two, think of your answer, and answer the question. It actually gives your attorney a little bit of space should the attorney need to object to the question. So take your time, take your breathers, listen, prepare, and answer the question. So just to recap some of the things that we talked about here in terms of the 5 mistakes that we talked about here today: lack of preparation, inconsistent testimony, volunteering information, displaying negative emotions, misunderstanding questions, and I'm going to give you one more. This is the bonus one: not having an attorney with you at the deposition. That's number 6. That's a bonus one. It's a free one. You don't have to pay for this one. Okay? If you have a deposition, whether you're a witness or whether you are a party, especially if you're a party, it's important to, at the very least, consider you have an attorney present with you to represent you at the deposition, so that way the deposition goes well and there's nothing else. You have no negative impact on that depo later on. But it's important to have representation at the deposition, whether you're a witness or whether you're a party to the depo. You're a party to the depo, most likely you have counsel. As a witness, consider having one, simply because sometimes witnesses becomes parties to the lawsuit as well. So that's a different conversation, a different topic, but I just want to make sure having an attorney present is something that I highly advise, which is, again, the theme of my book, Business SOS. Don't do it yourself. If you have any questions about this topic, please send me an email at rich@richsierra.com. If you want to reach out to us and you are interested in our legal services, my website is floridasmallbusinesslegalcenter.com. Our social media handle, Facebook, is at FSB Legal. If you want to watch the video of this podcast, we're at youtube.com at Richard Sierra. We're an X at Rich_Sierra, Instagram at FSB Legal. Our phone number is 866-842-5202. Remember that Business SOS, 8 common legal mistakes business owners make and how to avoid them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. If you like the show, please follow us. I appreciate a 5-star review. Share with your friends. We're on Apple Podcasts, Spotify, wherever you enjoy your shows. Until next week, this is Rich Sierra. Remember that my goal is to help you succeed.